Hello everybody, welcome back to the English Law Channel. So now I'm going to look at the law of leases. This is about a lot about landlord and tenant, which is sort of the staple of high street solicitors, those who deal in property. So there's a license, and that is someone giving you permission to do something on land, to live in it, to live on it, or do something else. So if a person is granted permission to occupy the land, this person might have a lease, and that gives the person statutory protection, creating an estate in land. Or they might personally have a license, which is a personal right. There might be contract permission, but they don't have statutory protections. There's no estate in land for them. So some landlords try to circumvent the protections which would be conferred on their tenants by creating a license, and they try to evade their responsibilities, these landlords. So the courts have seen this for what it is, and they say, well, they'll look at the substance of the situation. We won't look at the appearance. We'll have no truck with any sham devices. They won't accept it if the landlord says this is a license when in reality it's a lease. Okay, so there's a difference between leases and licenses, and this is quite important. So there's proprietary right in a lease, but there's a personal right in a license, but licenses can usually be revoked quite quickly. So someone who has a license has personal rights, contractual rights against the owner of the property that the licensee is occupying, and that's because the right is solely contractual. It can't be enforced against everybody else. Remember, legal rights bind the world. Proprietary right is one of them. Now, the distinction here is the holder of a lease has proprietary rights against the landlord, as well as having them as well as having contractual rights. So, in many cases, we regard leaseholders as having rights under the Rents Act, and this prevents them being thrown out arbitrarily. So, their arbitrary rights, can bind the whole world. So, a license in its simplest form means that you're not trespassing. You've got permission to occupy land or to utilize it in some other manner. So it's similar to easements. It's not exactly the same as an easement. So there's a bare license, in which case the revocation of that can be without notice for any reason, without stating a reason. A contractual license, which could be revoked if the license is broken. If the contract is broken. There could be a licensee by estoppel. So you can't always tell what the outcome is going to be, what a court will decide to do in any case. So you have to look at all the different possible outcomes when considering cases of this nature. So what is a bare license? Well, that is someone giving you permission to enter land or to utilize it in some form. And there's been no consideration, there's no contract here. Nothing's given in return for this permission. The license means that there can't be a claim of trespass against that person so long as he doesn't go beyond what he's been allowed to do. So Lord Justice Scruton in the Calgarth 1927 said, when you invite a person into your house to use the staircase, you do not invite him to slide down the banisters. For example, you invite someone in your house to do whatever, to go into this room. If they go into another room that they didn't have permission to go into, that's turning their behaviour into trespass. If you allow them onto your land to do a particular thing and they did something you didn't grant permission to, they're committing trespass. So a bare license can be created expressly or indeed impliedly. So there's an implicit license for anybody who has a proper reason to go up to your house, knock on the door, for example, a canvasser who's campaigning at election time, or someone doing a survey, or someone trying to solicit charitable donations, or a missionary trying to evangelize for his faith. So a bare license can be revoked at any time and without warning. So it's instantly revoked by the death of the licensor, or indeed by the sale of the land over which the license pertained. So, however, if a license is granted expressly, impliedly, to a whole group of people rather than to an individual, for example, postmen have this right, then no, it's not rescinded every time the house is sold. Postmen always have this right to knock on the door. Okay, contractual license. That is, as you would expect, a license in return for some consideration. So principles of contract law have applicability here. So the contractual relationship has been entered into. If a contractual relationship is entered by a family, this is regarded to have no legal effect. So this is a factor in deciding if a proprietary interest has been created through a lease. So quite often a contractual license has been used by the landowner in order to get around some statutory protection that will be granted the leaseholders. So, but courts have no tolerance for shams. There are other instances about contractual licenses, including paying to use a car park or a ticket to go and see something in the cinema. This is a contractual license. Okay, and it's flexible. However, it's also got revocability. They can bind third parties. If you behave very badly, when you've been granted permission as per a contract, you can be kicked out. So revocability. So that's an agreement. There's a contract, and there's a remedy for breach of contract. If you behave unacceptably, then despite having to pay to get in, you can be kicked out. When there's agreement over land, this can be unique. Well, all land is a bit different, every patch of land. So there can be some equitable remedies. Specific performance or an agreed contract could make a contract unenforceable. Werrell against Great Yarmouth Borough Council, 1981, is an example. There was a injunction there for fending breach. So equitable remedies give agreement, and they appear to be similar to property interest. There's Ashburn-Anstalt, and I'll come on to that later. Says there are differences, and says that contractual licenses are not proprietary estoppels. So this is a very vexatious issue. If there's a sale of a land by licensor, is an agreement something that can be enforced against third parties? Well, let's come on to third parties. So as per contracts, usually there's privity. Privity is a bit like privacy. So only those who are parties to the contract can sue on it. There are exceptions. Now, this has been changed a bit by the Contracts Rights of Third Party Act 1999, but there was an all-out assault on privity about land. Now, Lord Denning, who was deeply sceptical about privity in contract law, was the one who was leading the charge. So he delivered some famous judgment on Errington against Errington and Woods, 1952, Bean and Evans, 1972, DHN Food Distributors Limited against Tower Hamlets London Borough Council, 1976. So in Binions and Evans, Lord Denning created arguments about the enforceability of a licence against third parties who were relying on the existence of a constructive trust, created with the knowledge of the plaintiffs who had about the rights of the licensee. He said it would be utterly inequitable for the plaintiffs to tell the defendant out, contrary to the stipulation subject to which he took the premises. So that wasn't creating a property right in the licence, but a constructive trust, and that was his remedy for breach because of the third party's knowledge of the licence. So Ashburn-Anstalt and Arnold, 1989, the Court of Appeal, it reiterated the traditional belief about contractual licences not being binding on third parties in most cases. But the court also said that if there was an extraordinary situation, a constructive trust might be introduced by the court to oblige a purchaser to effectuate a contractual licence. So Lord Justice Fox said this in that case: before Errington, the law appears to have been clear and well understood. It rested on an important and intelligible distinction between the contractual obligations, which gave rights to no estate or interest in land, and proprietary rights, which by definition did. The far-reaching statement in Errington was not supported by authority, not necessarily the decision of the case per incuriam in that sense, and was made without reference to authorities which, if they would not have compelled, would surely have persuaded the court to adopt a different ratio. Of course, the law must be free to develop, but as a response to the problems that have arisen, the Errington rule, without more, was neither practically necessary nor theoretically convincing. By contrast, the finding on the appropriate facts of a constructive case trust may well be argued as a beneficial adaptation of the rules to new situations. So, usually a contractual licence cannot bind a third party. So it was also thought in the old days that the holder of any type of licence couldn't sue in trespass or nuisance. However, Manchester Airport plc against Dutton 2000 overturned this. But anyway, that was only by a 2/3 majority, and the dissident there was a property lawyer, become a judge. So licenses can be coupled with interests. If it's granted in connection with an interest, such as profit à prendre, as in being a right to go and take something from the land, like picking fruit, the person's given the right to shoot, who's hunting on the land, may have a license to enter the land so he can remove the things he's shot. The license is there to expedite the enjoyment of this interest, and the license can't be revoked before the interest has terminated. The interest in land is binding on the successors in title, as in who buys it or inherits it. The license that's attached to it is binding and can also be assigned to third parties. And there's license by estoppel. Licenses can come about through proprietary estoppel. If the estoppel is shown to a remedy awarded, maybe by license, to use the land or to live on the land, or operate a business on the land or something. Otti and Grundy 2003 is about this. So the Court of Appeal had to rule whether there was a detrimental reliance on the one claimant, and would that give a rise to any equity for that person. Anyway, so that's probably enough about licenses for the moment. Toodaloo.